I think if possible, we can slightly switch gears and perhaps move to a discussion of your work on sexual and gender-based crimes more specifically. So a lot of your work involves investigating and prosecuting sexual and gender-based crimes. So I was hoping that you could perhaps give us a little bit of a background and briefly explain the difference between sexual violence and gender-based crimes for those who don't know. And then perhaps get into a discussion of the challenges that arise fighting against gender-based crimes, specifically as a woman, and what are the advantages of that as well.
Gender-based crimes, of course, I mean, gender is a social construct, right? Defining roles that are socially constructed, and it's a fiction essentially, but a lot of people suffer persecution on the basis of gender. Gender-based crimes can be much, much broader than the sorts of gender-based sexual violence crimes that we are focusing on as international crimes prosecutors and investigators. So I am not an expert on gender-based violence in the broad sense of the term. What I do have an expertise in is, let's say, conflict-related sexual and gender-based violence, meaning atrocities that have some kind of a sexual component to them. And it's complicated, okay? It's been really interesting to watch the development of this. The reason, the reason why I got into it, I think, to begin with, is because, you know, when we were documenting human rights violations, but essentially we were documenting international crimes in Bosnia with Human Rights Watch after the war, immediately after the war. Okay, so literally I arrived there 2 months after the war ended. And you could not but be exposed, like there was no way to avoid being exposed to the severity of the sexual violence crimes that were committed. So if you were going there and going to communities and displaced persons camps and speaking with victims, survivors, you were going to face sexual violence crimes. And I think there was one victim in particular who really affected me deeply. And that was, I think, probably the one who brought my attention, I think, to, like, I don't like to compare severity of harm, okay? I don't think we can quantify that, and I would never, ever, ever think to do that. But the way in which she had emerged from those experiences really affected me. And I saw that it was somehow different, let's say. And it grabbed me for quite a while. And from then on, it was really very much on my radar. Now, at that time, I mean, I'm talking like 1996, 97, 98, when the tribunals were just getting up and starting, right? In that time, so the gender justice advocates, right, of which I'm the second generation, not the first generation, right? I'm talking like Rhonda Copeland and Patty Sellers and and Kelly Askin, all the let's say the adored, respected matriarchs of this field, right? And everybody was pushing for sexual violence crimes to be recognized and acknowledged as standalone crimes, not to be subsumed under something else. Not because they were quantitatively different, but because they were qualitatively different. The nature of the harm was different, and the survivors deserved justice that was tailored to the nature of the harms that they had experienced. Okay, that's what they deserved. So they deserve for it to be called rape if that's what they experienced and that's what they wanted it to be called, not just called torture, right? So there was a lot of advocacy to have standalone crimes of sexual violence in order to acknowledge the extreme, or let's say the unique nature of the impact on victims that sexual violence causes. And so it was incredible to be a part of that process, and especially to bring survivors into the courtroom to to be able to have the trial process be an empowering experience rather than a re-traumatizing experience was one of the challenges. That's a challenge of our lifetimes, right? That's the challenge. That is our core challenge, right? How do we bring justice that is respectful and that is tailored to the particular needs of the survivor, but make sure that the survivor is not sacrificed to the justice process, right? That is a big challenge, because the legal system is not, like a courtroom trial is not a compassionate, supportive environment. It just isn't, even in the best of circumstances. It's not designed that way. And so how do we bring in that respect while also abiding by all of the principles of due process and the rights of the accused that are pivotal to any effective justice system. So we did that, but what ended up, I think, happening, a couple of things ended up happening that we are now we're really focusing on overcoming. One of them is that in treating it as something unique or different, the sexual violence harm, we also kind of suggested that it's different, like either not as bad or maybe not as likely or foreseeable or something. And we ended up with a little bit of confusion about that, where sexual violence harms, there would be this idea that came down in some of the jurisprudence that it's foreseeable that this militia group would kill and torture non-sexually and loot and pillage and everything in this town, in this village, but it was not foreseeable that they would also rape. And so we kind of fed, I don't want to take responsibility for that, but I do think that the one of the things that has become clear is that because of the underlying entrenched misogyny that pervades everything and also pervades courts and the practice of law, and the underlying persecution of women in general and other, let's say, vulnerable groups, survivors of sexual violence, male survivors of sexual violence as well, that we hadn't really changed the fundamental, we hadn't changed the belief system and the mythology that underlied all of these decisions. And so I think, we have our work cut out for us, right? Now at this point, with this point of view, knowing what I know now, I would certainly still try to bring charges of sexual violence, standalone charges of sexual violence, but I would also, and it would be the choice of the victim completely, okay, that it's not my choice, but I would also recommend also charging non-sexual violence crimes, to charge the rape as an act of torture as well, to make it clear that it is just as grave and just as serious as torture and other forms of cruel treatment, which shouldn't be something that we have to prove. But the reality is that we still have to prove that. And the reality, so I would say that is one of the big challenges we face. And this is not a challenge that's unique to me as a woman, as a female prosecutor. But one of the challenges that we still face is how to bring justice that serves the victims, but advance the law and build a greater understanding of the fact that sexual violence doesn't need a different evidentiary standard. It doesn't have a different evidentiary standard, and that survivors of rape are no less credible than survivors of non-sexual torture simply because they're women or elderly or from indigenous communities and they don't speak the language that they speak in the capital. There's an enormous amount of discrimination that underlies all of this, and it impacts on how prosecutors decide to bring cases because if the witness is going to be assumed to be not credible, what is the prosecutor going to do? And these are crimes of sexual violence that for the most part don't have medical documentation because the crimes happened a while ago and the country was at war and there was no doctor available and there was no rape kit or whatever. And so witness testimony, I mean, in the special court for Sierra Leone, our cases, all of them, with the exception of the Taylor case, were based primarily, I mean, in very, very large part on witness evidence. And that requires the court to find the witnesses credible to give evidence, which requires them to actually think as highly of a rural, elderly, female, indigenous woman as they do a male younger from the city. And this is the reality of what we face in the courtroom. There is no legal standard that requires a different level of scrutiny, but that is the reality of what we face. So those are the challenges. As a woman, it's gotten a bit better as I've gotten a bit older. Look, I think any hardcore profession is still harder as a woman in many ways. And we still have to make choices that certainly our white male counterparts don't ever even notice. You know, you have to be, if you want to move forward in a career in international law as a woman, you have to decide whether you're going to tackle the sexism and misogyny that is going to come at you, or whether you're going to practice international law, because it's really hard to do both. Now, I'm sure a lot of my like enormously respected peers will disagree, and maybe some of them have managed to take on both. I know that I haven't managed to, and I have great admiration to those who have. So it is still very much very difficult, very extremely difficult to work in this field as a woman. At the time I was a trial attorney at the Yugoslavia tribunal, I was the only female prosecutor with small children at that level. And you know, the system is not meant, the system, at least that system, which I think is heavily modeled on the American kind of common law system, at least the ICTY system was modeled on that. And you know, that system is not set up for you to be doing anything else except that round the clock. Does it need to be that way? I don't think it needs to be that way, even respecting the rights of the accused to a speedy trial. But you know, there are certain realities that we have to face, and we make our choices. Yeah, hopefully over time the choices get easier. But I would say it's difficult, especially investigating in the field as a woman in conflict zones or post-conflict zones. It entails unique risks, let's say.
Thank you for sharing that. Are there advantages that come with being a woman, perhaps in the sense that, you know, you saying that you try to create the awareness that you would bring in some ways?
I think the advantage I hope is that those female survivors of sexual violence crimes or of any atrocity crimes may feel a comfort in connecting to another woman. I don't think that that's necessarily always the case, and I don't think it has to be a woman who investigates or even interviews survivors of sexual violence. That's not my view, but I do think that there is a comfort to that of the victim that I've experienced many times, and that's a beautiful thing. And so I think that's one part. I think another part that has an advantage of being a woman is perhaps there's a diversity of thought that we may bring to the law, which was originally developed by men, but maybe could use a bit of a a more diverse interpretation or type of practice, let's say. So creativity and ideas that we can develop by working with women's organizations and women victim organizations that are run by women, and you know, there are some ideas and sharing of ideas to create, like, to develop creative strategies, for example, of like witness protection or victim protection. You can develop those strategies in a way if you know, if you understand the community that the women are living in and what and how that operates. And so yes, there is definitely an advantage from that perspective. And I hope that over time that the more women that participate in this, the more the law is going to be more of a home for women practitioners as well. I'm sure that some of my women colleagues and peers find it already to be so, but I also know for a fact that many of them don't. And so I hope for that. And yes, I think that that being a woman and dealing with victims of sexual violence has it has a bit of an ease to it that you might not have if you weren't a woman. But I honestly, it's kind of hard to conclude that in a way for me, because I've, you know, been taught by and mentored by incredible men who are professionals who modeled for me that, you know, if you're doing your job right, you're doing your job right. And if you're empowering the survivor and focusing on justice for the survivor or the victim, then it really doesn't matter, you know, who you are or where you come from. That's what's important. So I cannot say that men can't do it, but and I would never say that. But I would say that there are some distinct advantages, and yeah, I think so.
What would you say the most important lessons that you've learned have been from the women that you have worked with and helped, whether it be survivors of sexual violence or local lawyers, people on the ground?
I think all in all, if we're talking about survivors and victims and survivors, I think what I learned from them is that most of the assumptions that are made about them are just wrong. Yeah. That they don't need someone to make a decision for them about whether or not they might want to testify or might be upset. They don't need someone. They don't need somebody to disempower them again. They know very well what they want, and they know very well how to decide that. They have a right to have the information brought to them. They will make their decision. But so this idea that sort of developed that, you know, oh no, we can't investigate sexual violence crimes because we don't want to re-traumatize the victims has kind of, it's important to not re-traumatize the victims, but that has sort of become a bit of an excuse to not investigate those crimes or include those crimes in cases. It's still viewed as a separate subject that needs a specialist, that needs a special kind of prosecutor, that needs a special thing, a special court, a special everything. And that's actually contributed to taking away the agency of the survivors and separating them out and actually blocking their access to justice more than it has to including them. So I have learned that that with respect, survivors are participants in the justice process. They want to participate. They want to face their perpetrator if they can. We're very often dealing with a superior of the direct perpetrator, and that. But at the national level, there is such a hunger for justice, and that if victims are engaged in the process from the moment that the investigation starts, and if they are consulted and an integral part of the process throughout, then even if the ultimate result of the trial goes wrong or doesn't go the way they want, they will have experienced it as an empowering experience. Okay. I mean, in Guatemala, the survivors of Rios Montt, I don't know if you know about this case, but this was a genocide case against a former president of Guatemala. he was convicted on appeal, but then at trial and on appeal, but then it was overturned by the Constitutional Court on a procedural ground. But the survivors who went through that trial, okay, this is like for crimes that happened in the 1980s, and the trial happened like in the past 10 years. So they're elderly, they have waited 30 years for justice, and they celebrate every year on the day of the conviction, which was overturned. Okay? You understand what I'm saying? They have a celebration. Why? Not because they didn't want him to be convicted, but because that wasn't the only point. Okay? That wasn't the only point. Okay? Their story has been told. They've had their day in court. There's documentation of the atrocities. If it's not that guy, it'll be another guy, and it has been other guys, right? So people want justice, but they want to be part of the process. They want to be engaged, and that's what I have learned from the survivors that I've worked with, and with all of the prosecutors and investigators and victim lawyers that Kathy and I are working with through PJI. That's a core part of the practice that we're sharing with them. So they ask us to help them on their cases because they've never prosecuted international crimes cases before. But the piece of integration and ownership by the victim community and building that relationship from the beginning so that victims feel a part of the process, are consulted in the process, that is something that we bring as a core part of our partnering and mentoring them on cases. And as like the main, let's say that not only the main way to bring justice to those whom we serve, but also the best way to present a strong case, because if you know your victims and your victims are engaged and involved, your case is going to be spot on accurate and true to what happened. And it's going to be compelling because the crimes are awfully compelling.